Welcome to the Lawyer Society Legal Podcast. In this episode, I'll be talking about two very interesting facts about Section 12(1)(a) of the Hindu Marriage Act 1955. As you know, Section 12 deals with voidable marriages and Section 12(1)(a) specifically deals with the ground of marriage not being consummated due to the impotence of one of the parties to the marriage. Now, I say one of the parties because as held in various judgments, it could be the wife or the husband who is impotent. It is not like only the husband could be impotent, it could be the wife or the husband who is impotent. And as observed by the courts, it is not just physical impotency, it is also psychological. It could be just the fact that that person is not inclined towards sexual intercourse, so the marriage hasn't consummated, and hence the marriage can be annulled under 12(1)(a) even if the person is physically able but psychologically incapable of having such a sexual life with the partner. So having said that, let us proceed into the two interesting facts I was talking about. In various cases, the parties usually file 12(1)(a) along with 12(1)(c). That is, they allege that the fact of impotency was concealed at the time of marriage to get the consent of the other party. So is it necessary to tag 12(1)(c) along with 12(1)(a)? The answer is no. But is it necessary to allege that there was any suppression of fact? The answer to that question is also no, because when you read 12(1)(a), it is evident that it is not necessary that the fact of impotency must have been concealed from the petitioner who is subsequently filing a petition for annulment. So suppression of facts or concealment of facts is not even essential to this. When you read Section 12, subsection 2, you have two clauses which impose certain conditions for the applicability of grounds given under 12(1)(c) and 12(1)(d). But there are no such conditions given for the applicability of 12(1)(a). For instance, if you read 12(2)(a), you find that there are two conditions given for the applicability of 12(1)(c). Now, 12(1)(c) talks about obtaining the consent of the petitioner by concealing certain material facts at the time of the marriage. So, if you read 12(1)(c) along with 12(2)(a), it is clear that if after the petitioner came to know about such concealment of facts, if he gave consent to live with the partner thereafter, then he can never file for annulment of marriage on such ground. If he doesn't consent, he still has only a year of limitation period to prefer a petition under 12(1)(c) seeking annulment of marriage. So that is how you must be reading 12(2)(a). But there are no such conditions given for the ground available under 12(1)(a). So that is the first interesting fact, that there is no requirement of concealment of facts. What is the next important fact that you must know? It is not necessary that the party must have been impotent at the time of the marriage. This is clear from just a bare reading of the provision, but if at all you have any doubt regarding this, you can actually refer to the 59th Law Commission report, which was submitted in the year 1974. This particular Law Commission report ended in the 1976 amendment of the Hindu Marriage Act. Now, in this particular amendment that came out in the year 1976, certain changes were made to several provisions, and one of those changes was removing the words "at the time of marriage" from Section 12(1)(a). Now, this is because the Law Commission suggested or recommended that these words must be removed, because this will prevent the party from filing for annulment of marriage if the impotent nature of the respondent comes into existence after the marriage. That is, if the party is not impotent at the time of the marriage but subsequently became impotent, that can also be a ground for annulment of marriage, and hence the words "at the time of marriage" must be removed from the clause 12(1)(a). Subsequent to such a recommendation, the Parliament accepted such a recommendation and removed those words from 12(1)(a). So right now, when you read the provision, there are no conditions regarding the time when the party must have been impotent. So there is no requirement of concealment of facts. There is no requirement that the party must have been impotent at the time of marriage. So needless to say, if you are going for 12(1)(a), you don't have to tag 12(1)(c) along with 12(1)(a). You can just go for 12(1)(a) because that will be sufficient if you are able to prove that the marriage hasn't consummated and it is due to the other party not being able to consummate the same. I hope you found this information useful, and I have some more information regarding 12.1c which we will see in one of our future videos because it is very interesting. I read 12.1c and some more case laws on the same. I will be sharing the same with you guys in the coming episodes. Do subscribe to Lawyer Society on YouTube if you are watching this on YouTube. Do follow us on Spotify if you're listening to this on Spotify. If you want more such interesting legal information, do support us by sharing this video or sharing this podcast with your friends and everybody else you know from the legal community. Thank you. Until next time.